Hi everyone. Today we're going to delve into a quite frequently asked question. Do family offices need an SFC license? First, let's look into the definition of a family office. A family office manages assets for rich families. A family office is only responsible for making investment decisions and does not hold client assets. The assets are usually kept by a custodian or a trustee. The assets are still the rich families or their trusts and does not belong to the family office. The profit and loss caused will be belonging to the rich or the trust. A family office can be a single family office or a multi-family office. There was a circular published by the SFC recently regarding the licensing obligations of family offices. It briefly introduces what a family office is, scenarios where a single family office needs not a license, and which types of license a multi-family office needs. You can see from the link the circular. Under what circumstances do we need a license? Why is the license so important? Under the Securities and Futures Ordinance, certain businesses are classified as regulated activities, and conducting those will need an application of a license with the SFC. For instance, dealing with securities, dealing with futures contracts, asset management. In layman language, under a subsidiary legislation, to deal with or manage securities and future contracts for a third party, either an individual or a company, for a fee or a benefit, or to give advice on securities and future contracts, will need the approval from the SFC. As in, securities firms buy and sell stocks, funds, and futures options for clients. But there's an exception, when the employee is doing so for the employer. They do not need a license. Why? Because the employee is representing the company. They are managing those assets on behalf of the company. So basically, the company is dealing with its own money. No third party is involved, therefore is not a regulated activity. Let me give you an example of a regulated activity. Coffee deposits money into her own client account at Handsome Asset Management. Handsome Asset Management helps her buy and sell stocks, funds, and other investment products Coffee is pleased with. Doing so, Handsome will charge Coffee management fee or brokerage fee. Coffee would be the third party whose assets are taken care of by the licensed corporation Handsome Asset Management, and money is rewarded to Handsome for the management. Below is the situation where license is not needed. When the family office does only proprietary trades instead of trading for a third party, there is no need for a license. There are two key roles we're focusing on. We need to identify the assets owner and the assets manager in order to reveal the licensing needs. Let me give you some examples. First, if the rich starts a company and hires staff to make investment decisions and manage buy and sell of securities and future contracts. Remember what I said before, the staff doing the management for the employer. The staff is representing the company and doing the management on behalf of the company, so there's no need of a license. On the other hand, if the rich starts a company and lets its subsidiary manage its buy and sell, let's look at the graph on the right-hand side. When Li Hengxin Limited wholly owns Li Hengxin Family Office, and Li Hengxin Family Office invests in whatever it wants to invest in on behalf of Li Hengxin Limited. Because Li Hengxin Limited is the only owner of Li Hengxin Family Office, the decision maker is the asset owner or its subsidiary, so there's no need of a license. Because no third party is involved in this case. Let's move on to the second example. The trustee wholly owns a company as a family office. That family office manages the trust as a wholly owned subsidiary. Can you tell whom the assets under management belong to? Who is the asset manager? Are they the same company? You can literally see the answer from the graph. The assets belong to Trust C, where Trust C happens to be the owner of Trust C Family Office. Trust C Family Office serves the asset management function as a wholly owned subsidiary. The word wholly owned is quintessential in determining the licensing needs. A wholly owned subsidiary managing assets for its holding company will go perfectly fine without the license. So, Trust C Family Office does not need to apply for the SFC license. Let's go on to the third example. Family Office puts assets into a trust and trades on behalf of the trust. The trust is wholly owned by the family office, and the family office has full discretion to manage the asset portfolio. In this case, do you think Cindy Family Office needs to get the license? We can see that Cindy Family Office is not only the assets owner, but also the assets manager. Investing your own money in your own accord is not something you need a license to do. So, Cindy Family Office does not need to get the license. By viewing the above examples, we can see there are two vital questions in determining whether the family office needs a license. The first question is the asset owner the shareholder in the meanwhile the investment decision maker or the decision maker's holding company or wholly owned subsidiary? If yes, and there's no third party involved, there is no need of a license. If not, but you're talking about the employee managing assets for the employer, due to the nature of the employment, the employee is representing the company and dealing company's money on the company's behalf, so there's no need of the license. If the asset owner is not the decision maker, the asset manager, in the meanwhile, charges some benefits from the asset owner, like money, the asset manager will need a license to do so. The second question is, are the assets under management securities and future contracts? If yes, heads up. If no, forget it. It has nothing to do with an SFC license. Now it's time to have some quizzes and see if you can understand me earlier. Let's look at case 1. If Conrad wholly owns Conrad's family office and Conrad's family office wholly owns Conrad Family Office Fund and in the meanwhile manages the fund. Does Conrad's family office need a license? We can see from the graph, Conrad is the first individual we encounter, and Conrad's family office is the second individual, independent from Conrad. As a company, it has its own responsibilities and liabilities. And who's the owner of the Conrad's Family Office Fund? We can see that Conrad's Family Office is the asset. In this case, when Conrad's Family Office is making its own decision and manages its own money, decision maker and the asset owner of the asset, which is the Conrad's Family Office, is the same company. There's no need of an SFC license. The second question. In this case, Conrad and Ms. Chen owns half of CK Salon's shares respectively. CK Salon, which is a company independent of the shareholders Conrad and Ms. Chen, wholly owns CK Salon Fund and manages the fund alone. Can you tell if CK Salon is conducting a regulated activity and hence need an SFC license? The answer is, let's think about who is the owner of the fund. Despite the fact that Conrad and Ms. Chen concertedly owns CK Salon, CK Salon as an individual, as the nature of a company, should be seen separately from its shareholders. Thus, Conrad and Ms. Ko's roles are not important in the perspective of licensing need. Now, CK Salon alone owns the CK Salon Fund and manages the fund itself, entailing that no third party is involved. CK Salon Fund investing on its own behalf will raise no need for a license. Let's move to the next instance. Conrad is the only shareholder of Conrad Co. Limited, while Conrad Co. Limited holds CK Asset Management's 100% shares, and in the meanwhile is the sole investor of the CK Fund. CK Fund, on the other hand, is managed by CK Asset Management. Do you think CK Asset Management needs a license for the management of CK Fund? Once again, Conrad Co. Limited as a company is now legally independent from Conrad Co. So by now you should know that you can simply skip the shareholders part. Conrad Co. Limited is the assets owner and also the only owner of the asset manager, CK Asset Management. CK Asset Management, as a wholly owned subsidiary of Conrad Co. Limited, manages CK Fund for its holding company, matches the exemption conditions, and hence CK Asset Management will not need to apply for a license for managing CK Fund. Next question. Conrad Co. holds 55% shares of CC Asset Management, while Coffee holds 45% of the shares. CC Asset Management is founded to manage CK Trust and Coffee Tea Trust. Do you think CC Asset Management is obliged to spend money and time on the SFC license application? I believe all of you will skip the Conrad and Coffee part as will I. Now with CC Asset Management managing two trusts in the meanwhile, is CK Trust wholly owned by CC? No. Is Coffee Tea Trust wholly owned by CC? Neither. So if both trusts are not wholly owned by the asset manager, there is no exemption on the license and therefore CC Asset Management will need to spend a few months on the SFC license application in order to manage those two trusts at the same time. Now hope the fifth example will be easy for you. Conrad Co. owns 70% of Double C Asset Management as well as 70% of Animal Shelter Fund, while Coffee owns 30% shares of both Double C and Animal Shelter Fund. Double C's only duty is to manage Animal Shelter Fund. Is Double C Asset Management required to obtain a license from the SFC for this managing business? Let's not confuse by the red and orange parts as Double C is legally an individual. If you cover up the Conrad and Coffee's names, you will see clearer the relationship between the Animal Shelter Fund and Double C. Is Double C the asset's owner? Any direct relationship between Double C and the fund? Apparently, the fund's owners are the third parties to Double C, meaning the fund does not belong to Double C while Double C is managing its portfolio. Double C doing this business without an SFC license, very likely a Type 9 license, will be a breach of the Securities and Futures Ordinance and will lead to serious consequences. So in this case, Double C had better apply for a license before conducting such management. And congratulations, this is the last example I got here. Conrad Co. owns 20% of shares of CCC Asset Manager, while Coffee owns 55% and Cindy 25%. Below, we can see that CCC Asset Manager's business is to manage Ken's properties, Flat A and Flat B, the speculation, bidding and purchasing of gold, artifacts, antiques, and wine. Does this asset management business require a license? The answer to the question is surely no. None of the assets CCC Asset Manager is managing fall into the definition of securities nor that of future contracts. Why do you still need to think about the futures and future contracts ordinance while there is nothing to do with securities and future contracts? So, no. To sum up, two roles are of utmost importance when coming to think about whether a third party is involved, whether the company is managing its own securities and futures contracts. You should be well aware of the asset owner, aka the shareholder, and the investment decision maker. If the ownership equals to the management, there is no need for an SFC license. For instance, like if the assets belongs to the asset manager, the company making investment decision, say an asset manager managing its own trust, or if the assets are managed by a wholly owned subsidiary, say a trust is being managed by the asset manager, while it is also the only shareholder of the asset manager. The SFC license will be redundant. It is not a regulated activity and needs not the license then. To wrap up, allow me to repeat these two key questions. Is the asset owner the shareholder, in the meanwhile, the investment decision maker, or the decision maker's holding company or wholly owned subsidiary? If yes, and there is no third party involved, there is no need of the license. If not, but the assets are managed by the employee for the employer, there is no need for the license either. If not, but the company, the asset manager, obtains some benefits from the asset owner, like fee, there is a need of the license. The second question is, are the assets under management securities and futures contracts? If yes, you will need to pay attention to the license need. If not, you really don't have to watch this video this far. Thank you all for watching this video. If you need to take the HKSILE or the IIQE exams, welcome to explore our study materials. You can browse the following website. If you have further questions regarding the SFC license, the HKSILE exam, or the exemptions on exams, please feel free to contact us by the following methods. Until next time.